Good morning, everybody. This is the second day of part 2 of the Tranche 2 hearings conducted by the inquiry. We are on the second day of openings, and Mr. Wood, King's Counsel, is going to open now. Mr. Wood, your original time estimate has been extended because of the volume of things that you have to say.
Well, thank you very much, sir. I obviously make this opening statement on behalf of all the core participants represented by Hodge, Jones and Allen in this tranche of the inquiry. I hope that served upon the inquiry as directed, and I believe now to be put online on the inquiry's website, is the 80-page written opening prepared by our team with overview and input from all of our lay clients. That they and you can now view that document as I make this address. And you have, though, quite understandably, placed time limitations, and I'm very grateful to you, sir, for extending the time limitation, because the opening statement that I'm going to make obviously covers 12 core participants, 6 organizations, and deals with a number of miscarriages of justice. So I turn to the introduction. During this Tranche 2 period, the Special Demonstration Squad, the SDS, committed some of the most serious abuses of state power against activists in modern times. They displayed, we say, a complete contempt for the basic rights and dignity of those they spied upon, as well as a disdain for the justice system. They acted, we say, as if outside or above the law. And we urge you to uncover those abuses of power and to identify the individuals and systems that enabled them to happen. In paragraph 2 of our uploaded opening statement, I have listed all the core participants who we represent and the organizations they participated in, and I will briefly introduce them to you. But in this address, I will then proceed to deal briefly now with the framework within which the SDS operated, the targets and tactics of the SDS, miscarriages of justice the SDS engendered, particularly relating to the core participants who I represent, and the commission by those officers of some criminal offences. And assuming, and I hope now with the time available, just to make some procedural concerns expressed by some of those we represent. So we turn briefly to the groups and individuals we represent. In general, they were activists linked either to London Greenpeace or to the Women's Peace Movement, the Trafalgar Square Defendants Campaign, or to various groups concerned with animal rights. They held differing political views and correspondingly employed a variety of methods of protest, including direct action. There was no unified approach to their individual or group campaigns. Not all of these core participants were pacifists. However, none of them, we say, encouraged or promoted direct action which would cause any physical harm to persons at all. So, sir, we start with a brief description of London Greenpeace, which is one of those organizations you will be considering. London Greenpeace was established following the publication in 1971 of the pacifist magazine Peace News, of an article about how individuals could take action in their own lives to preserve our ecosystem. The group was in fact the first Greenpeace group in Europe and one of the first 3 in the world. In 1987, the new, better and well-known national organisation Greenpeace UK Limited was set up. London Greenpeace was invited to merge into it, but it declined to do so. In a document produced in the 1970s, the group described itself as follows. Greenpeace London has existed for many years as an autonomous group of activists. We share a non-violent, libertarian opposition to the exploitation of our ecosystem. Our origins are in a special concern for everyone's personal responsibility to the environment, and in particular, commitment to oppose the ravaging of the environment by militarism. So London Greenpeace campaigned on environmental and social justice issues, initially primarily against nuclear weapons testing, but later encompassing a wide range of issues, developing a notable interest in animal rights in the mid-1980s. LGP deliberately remained a small group of activists without leaders or formal membership. Decisions were taken by initiative and consensus of those involved, whilst respecting their differences. It encouraged people everywhere to organize and to network with others to build up strong and lasting movements to effect real change. It had an open and democratic structure. It had had offices in North London and held open meetings on a weekly or fortnightly basis. I now move to list some of the core participants who we represent, who were particularly active in the group in the 1980s. I start with Albert Beale, sir, who is to be called before you on Monday, the 11th of November. Mr. Beale is a lifelong activist dedicated to issues of peace, justice, and sustainability. A committed pacifist, atheist, and anarchist, his interests in these concepts began early in life. His passion deepened while at university when he became involved in Brighton pacifist action. His early activism fueled his interest in anti-national, anti-military activism, and over the years he became involved with several key organizations, such as War Resisters International and the Peace Pledge Union. He was on the staff of Peace News for much of the 1970s and virtually all of the 1980s. He was heavily involved in London Greenpeace during the 1970s, attending virtually every meeting, although his involvement reduced somewhat during the 1980s due to other commitments. He became more active again in the 1990s during the defense campaign surrounding the McDonald's libel action. Martin Lowe was also involved in the group. He's to be called before you on Monday, the 4th of November. He describes himself as a pragmatic anarcho-pacifist. He has a lifelong and unwavering commitment to nonviolence. His activism began in 1968 when he attended his first protest and became a member of the Peace Pledge Union, the British section of War Resisters International. Since then, he has participated in numerous peace movements. He became a vegetarian in 1970 and later a vegan. He views this as an aspect of his non-violent activism. He was involved in London Greenpeace from 1973 to about 1985. His involvement brought him into contact with a number of campaigns, including, but not limited to, the National Peace Council, Operation Namibia, an organization called Partisans, and the Torness Alliance, amongst others. With a strong background in the peace movement and anti-nuclear campaigning, Martin Lowe was uncomfortable with an increased focus on animal rights issues that developed within the LGP in the mid-1980s. Sir Dave Morris, you heard from in phase one of this tranche, and you will hear again from him not only in a brief opening on the libel case later today, but during the course of evidence he will give on Tuesday, the 5th of November. As he told you in phase one, he's been an activist since the mid-1970s. He's known for his involvement in various social justice and environmental and community groups and campaigns. These were generally focused on anti-capitalist, anti-corporate, and environmental issues. In the last 25 years, he's focused mainly on local community campaigning. He was involved with London Greenpeace from 1982. And in this phase, he was also heavily involved in organizations, the Tottenham Against the Poll Tax, set up in November 1988, and by extension was also influential in setting up the Trafalgar Square Defendants Campaign, which was targeted by the SDS officers. He, with others, initiated and coordinated the Trafalgar Square Defence Campaign, set up in 1990 for the 491 people arrested during and following the anti-poll tax demonstration in 1990. The demonstration was on the day before the controversial poll tax was due to be imposed, and followed weeks of residents' protests throughout the country. The central London demonstration had, we say, been attacked and broken up by the police, which led to the arrests and disturbances. The Trafalgar Square Defence Campaign was in fact a traditional defence campaign in its aims and its ways of working. It was coordinated through open, collectively run meetings and provided welfare and legal support to those arrested. It campaigned for the charges to be dropped, organised pickets of legal hearings and prisons, and produced newsletters and general publicity. It ensured the anti-poll tax movement stayed united and strong in the face of continuous media and government attacks. And by the end of the year, over 14 million people were refusing to pay the tax. It was, we say, unenforceable and was therefore scrapped. Now, as you know, Dave Morris was closely associated with Helen Steele through their joint roles as defendants in the libel trial, which was, we comment, the longest trial in English history. Mr. Morris represented himself on that and will address you separately on it. But I turn now to Helen Steele, who is to be called before you on the 27th of November, according to the current timetable. Yesterday, you heard movingly from Miss Kilroy of King's Counsel how Miss Steele was grossly and cruelly sexually manipulated and abused by the undercover officer John Dines. She was and is a lifelong committed activist who became interested in environmental and animal rights issues as a teenager. In December 1988, she took part in a massive women-only protest, Embrace the Base, at Greenham Common. She was inspired by seeing and being in the company of so many women taking action together for peace. She moved to London as a 17-year-old and started volunteering at the offices of the British Union for the Abolition of Vivisection in London, and then at the Animal Liberation Front Supporters Group, which were based in the same office. From about 1984, she was involved in other groups such as the Haringey Community Action and the Haringey Anarcho-Feminists. She was involved in running Support Animal Rights Prisoners, SARP, from 1985 to 1990. And she became involved in London Greenpeace in the late 1986, early 1987, and was involved in a range of campaigns, including environmental issues, peace and anti-nuclear protests, and anti-capitalist protest campaigns against racism and sexism, gay rights, justice campaigns, and workplace struggles. We say, not only has Helen Steele been cruelly abused by the STS officer Dines, but none of her political conduct could ever begin to justify the gross intrusion into her life caused by the surveillance to which she was subjected. And so can I pause there to say that I note that you are looking at the long 80-page opening and I undertake to supply you at the conclusion of this address with a copy of the note from which I'm currently speaking, which is obviously a much abbreviated one, and I hope that will help you, sir, as I deliver it. It's not necessary to try and find it in the larger note. I will ensure that you have this note copied.
Thank you.
So can I turn on to Gabrielle Bosley? To be called before you on Wednesday, the 6th of November. And she was raised with a strong sense of ethics, kindness and compassion, and a deep love of nature. She has interests in issues involving social justice, the environment, and animal rights. As a reflection of her commitment to these values, in 1985, she became a vegan and would also participate in hunt savving. However, her method of campaigning has always been rooted in peaceful, non-violent activism. From 1986 to 1988, she was actively involved with London Greenpeace, regularly attending meetings and often helping with administrative tasks such as preparing information packs and responding to written inquiries. Sir Paul Gravitt, who will be called before you on Wednesday, the 13th of November, has been an anarchist and activist on many social justice issues, particularly animal rights. Since the early 1980s, he was active with London Greenpeace from 1986. He attended meetings regularly and was part of the collective, helping to produce a number of documents and organising campaigns, including those against McDonald's and Unilever. He also organised a number of public meetings on a variety of topics. As well as his involvement with London Greenpeace, Paul Gravitt was also involved with several animal rights organisations. In 1982, the ALF supporters group, ALFSG, was set up, and Paul Gravitt became a member. From 1988 to 89, he took over temporary responsibility for certain organisational tasks. He also participated in lawful direct action such as hunt sabotage. He was also involved in another number of other animal rights groups, especially Islington Animal Rights, later Hackney and Islington Animal Rights, which campaigned against the local animal laboratory called Biorex. In 1991, Paul Gravitt sought to re-energise the animal rights movement by launching a group called London Boots Action Group, LBAG. And I turn to say a few words about that group. It was launched at a public meeting in Conway Hall in November of 1991 with about 60 to 70 people in attendance. Paul Gravitt was one of the founders of the LBAG, and its principal aim was to stop vivisection, particularly the animal experiments conducted by Boots. It was a street-based protest group which had about 20 active supporters and over 100 members. The administration was carried out mostly from Paul Gravitt's home address. It too was targeted by undercover officers, even though it clearly posed no threat to the state, and the SDS reports assessed the likely disorder at upcoming events as, in inverted commas, none. Another group is London Animal Action, or LAA, which was formed in 1994 from a collective of animal rights groups in London, including London Boots Action Group. The ultimate aim of the London Animal Action was ending the exploitation of animals by bringing about animal liberation. Its most prominent campaign was against the London fur shops, which were picketed. It also campaigned against vivisection, the meat and dairy industries, hunting, circuses, and zoos, and it advocated veganism. A series of undercover officers joined the LAA. The ones that have been identified in this phase are Andy Cole, HN2, HN1, Matt Rayner, HN26, Christine Green, and HN60, Dave Evans. At that time, HN10, Bob Lambert, had a managerial role over some of these officers. As well as infiltration by undercover officers, LAA was the target of corporate spies who worked for the fur trade and vivisection industry. And on behalf of the core participants, we have concerns over the level of information sharing between the undercover officers and the SDS generally, and corporate spies, and the subsequent use of this information in civil proceedings against LAA. It's an issue that arises, of course, in the McLibel case as well. And we hope that you will investigate that. Sir, I move to Claire Hildreth, who is to be called before you on the 11th of December. She's another of our core participants. She was one of those who was active in the London Boots Action Group and the LAA. She became involved in animal rights and human rights activism in 1992 when she attended a march with a work colleague and was handed an LBAG leaflet. Her employment history has always involved the type of work that helped people, and she has worked as a residential support worker, an immigration advisor, and a citizens advice supervisor and caseworker. Claire Hildreth felt very passionately about the rights of animals to live free from human exploitation and abuse. She did not want anyone to be hurt and thought that there were more effective ways of bringing about change. She was not an Animal Liberation Front activist and was never involved in ALF-type activity. Claire's campaigning and personal life were infiltrated by undercover officers, namely Matt Rayner and Andy Coles, your HN1 and HN2. HN1 embedded himself into Claire's life, and the two formed a very close personal friendship. Claire feels used and deeply hurt by his actions. So I now turn to the Animal Liberation Front, the ALF, and its supporters group, the ALF-SG. The aims and methods of the Animal Liberation Front activists were summarized in a leaflet circulated in 1980, which states, aims. Our long-term aim is simply to end totally the exploitation of animals by human beings. In the short term, we hope to save as many animals as possible from suffering. Methods. Our methods are direct action. This usually takes two forms which are often combined in one action. One, rescuing animals from establishments where they are being or will be subjected to suffering. These animals are either released into the wild if it is thought that they will stand a reasonable chance of survival, or found good homes, destroying or damaging property used in the process of causing suffering to animals. Reverence for life. In all actions, we take the utmost care that no harm should come to either human or animal life. Activists could claim acts of direct action as ALF actions if they fulfilled these criteria. However, there has never been a formal or informal group or organization that can correctly be called the ALF. ALF actions were classified by their aims and not by who carried them out. The actions took many forms. One of particular relevance to the inquiry was the use of improvised incendiary devices in stores which sold fur. As set out in publications by the ALF activists at the time, it was never intended that the stores should burn down. The aim was for the device to start a small fire which triggered the sprinkler system, causing water damage and consequential economic loss. The devices did not explode and were timed to go off in the middle of the night when the store was empty. Now, whilst the ALF did not exist as an organization or group, there was, however, an office known as the ALF Supporters Group, or the ALF-SG, which, as its name suggests, consists of supporters of ALF activity The group did not take part in direct action. It had a press officer and would produce publications relating to the causes of animal liberation. One ALF press officer for a short period was Robin Lane. I turn to him. He is to give evidence to you on Tuesday, the 12th of November. He is a committed vegan of 42 years and passionately opposes the abuse of animals. He first became involved in the animal rights movement in 1982 with organizations campaigning against animal rights, testing and abuse, such as the BUAV and South London Animal Movement, SLAM. In 1986, Robin Lane left SLAM to form an organization called RATS, a fundraising group which produced leaflets with a small membership. In 1986, Robin Lane took over the role of ALF-SG General Manager between August of 1986 and June of 1988, and focused some of his activism around the press office role in this period. In his role as ALF press officer, he produced literature, including the action reports and a diary of actions, and he also spoke publicly on behalf of the ALF-SG and liaised with the media. He was a spokesperson. Robin Lane continued to campaign for the animal rights movement through various vegan environment pacifist groups, and he was a founding member of the Campaign Against Leather and Fur, known as CALF, in 1989, and London Animal Rights Coalition, known as LARC, in 1994, which was one of the groups that merged to become the LAA. So I turn then to Jeff Shepherd, who is to give evidence before you on Thursday, the 14th of November. He was a committed animal rights activist in the 1980s and the 1990s. He was convicted of 2 serious offences. In each case, a different undercover police officer was active and engaged in conduct, which casts doubt on the safety of his convictions. Those 2 convictions, first Jeff Shepherd and another activist, Andrew Clark, were convicted of offences including arson, committed in July of 1987 at Debenhams stores. They were alleged to have been involved in the making and planting of improvised incendiary devices. Now, HN10, Bob Lambert, who's to be called before you in early December, was, we say, intimately involved in planning and carrying out this action, including, apparently, planting the devices in the Harrow store. That was the first matter. The second offence was when Jeff Shepherd was later convicted of a firearms offence committed in May of 1995. He was alleged to have acquired and possessed a shotgun. This will also be addressed later in our submissions, but again, we say now that the undercover officer, HN1, Matt Rayner, played a significant role in this offence, not least in encouraging Jeff Shepherd to become re-involved in animal rights direct action following his release from prison for the Debenhams matter. During that period, one of Matt Rayner's supervisors was none other than Bob Lambert himself, who had played a central role in the Debenhams incident. The roles the undercover officers played in these serious matters were never disclosed to the court or the prosecution during Jeff Shepherd's criminal proceedings. The use of the SDS undercover officers to obtain convictions turned a unit, we say, that had been designed to obtain long-term intelligence on political movements into one aiming to secure criminal convictions, but without any of the legal safeguards in place for more usual undercover operations. The SDS, with its paramount objective of maintaining cover, rather than ensuring a fair trial with open justice, was completely unsuited to this task. These incidents illustrate all the flaws inherent in the long-term deployments of undercover officers developed by the SDS and demonstrate the SDS's, we say, disdain, effectively, for the criminal justice system. So I turn briefly to Greenham Common and the women's peace movement, for you heard from witnesses so far as this is concerned in phase 1. You heard evidence from Jane Hickman, Rebecca Johnson and Hilary Moore, who were involved in different capacities with the Greenham Common Women's Peace Camp and its associated groups. They share, then and now, a commitment to making the world a better, safer, and more peaceful place, and to feminist principles of political organization. Because you have heard from them, I do not propose to read out paragraphs 40 to 44 of our note. But safe to say that, as we do at paragraph 44, that there was a stark lack of justification for the deployment of undercover officers, other than the apparent whim of the then Prime Minister, Margaret Thatcher. So I conclude this section. In paragraphs 15 to 19 of its opening, delivered yesterday, the Commissioners' Council listed a catalogue of matters said to have been perpetrated by animal rights activists in order to seek to justify the unsupervised long-term infiltration which took place of supporters of animal rights. It is of note that the dates and times or circumstances of those particular allegations are not given, but even if those matters occurred during the course of this phase 2 period, we suggest that it cannot justify the long-term deployment of undercover officers on the tasked way it is done on the SDS model. In failing to make distinctions between the various forms of activity carried out by animal rights groups, failing to distinguish ALF actions from the animal rights militia, uncritically describing lawful protest at the homes of those centrally involved in animal rights abuse as terrifying, and failing to respect the obvious difference that exists between the ALF itself and those who are prepared to speak publicly about it in the ALF supporters group. The Commissioner's opening statement repeats many of the mistakes that we find in the SDS's response to the animal rights movement. The Commissioner claims that in many cases, militants engaged in terrorist activity, despite the clear evidence of the Security Service in its assessment in 1991 that only a very small part of such activity qualified as such. The broad description of animal rights activists as militant simply displays a problematic failure to respect relevant differences between the groups and the individuals concerned. We say it is of note that the untargeted deep infiltration of SDS officers during this period does not appear to have discovered any individuals engaged in the kinds of life-threatening activities described. It is of particular note that those amongst our clients who were found by the courts to have engaged in imprisonable activities did so only with the support and encouragement of those SDS officers who are to be called in this phase of the inquiry. You may feel it right to conclude SDS officers sought to encourage such activity so that amongst the policing community, it could use them to enhance its standing as a unit within the Metropolitan Police and apparently justify applications for continued funding. The Commissioner seeks to say that there was a clear justification for the covert infiltration of militant aspects of the animal rights movement. Our submission is that infiltration can never be justified on a purely speculative basis. These long-term deployments were never justified and never properly reviewed. This inquiry is to examine the actions of the SDS and undercover officers on the SDS model. It is not concerned with whether undercover operations were ever, on an occasion, justified or came to be used for beneficial purposes. We say that the deployment of the undercover officers on the SDS model was not justified, even in principle, against any of the groups we represent or individuals. We also say that the flaws in using SDS officers are clearly displayed in the criminal prosecutions of those involved in animal rights activities, which resulted from the SDS operations. The highly intrusive reporting on campaigning groups by the SDS in this tranche was, we say, an outrage against civil liberties. The actions of the undercover officers involved, we hope, will be fully exposed as entirely without justification. So I move to our chapter 2, which is really chapter 1, about the framework which the SDS operations took place. I recognize that is a very lengthy chapter. It is between paragraphs 46 and 113. And I'm going to try here really simply to focus it in 4 short paragraphs. We invite you to give careful consideration to our detailed submissions in those paragraphs. But due to the time restrictions, we do not propose to deal with them in any detail. We submit it's important that the inquiry keeps a solid focus on the structure within which the Special Demonstration Squad operated. And this is not limited to its place within the Special Branch or the Metropolitan Police, but involves consideration of its relationship to the Security Service, the Home Office, the Cabinet Office, and individual politicians. Now, we set out in those paragraphs details of the operational influence of the Security Service on the SDS from paragraphs 50 onwards. In summary, the evidence shows the Security Service and the SDS working alongside each other in close liaison at all levels, with Security Service interest permeating the work of the SDS. As SDS manager, HN 115 Tony Wade states, he had almost weekly contact with the Security Service, and the SDS would always seek the views of the Security Service before deciding on groups to target. Now, we also set out in that written opening the interest the Security Service had in groups connected to the core participants we represent. We submit that the evidence demonstrates the intense political interest and influence on targeting by the SDS, both in the Security Service and the government. And the SDS operation against London Greenpeace, the animal rights movement, and Greenpeace and others was, and we invite you to conclude this, at its heart, political. Now, so I turn then to our second limb, which starts at paragraph 114. And again, I'm going to seek to deal with it briefly. Targets and tactics. This period saw the deployment of many unacceptable and abhorrent tactics deployed by the SDS, and we set them out briefly now. First of all, we suggest there was an oblique approach, which we used to describe the many groups targeted by the SDS, which did not themselves pose concerns either for public order or subversion, and this was recognized by the SDS. The apparent justification for their infiltration was to seek to obtain intelligence on ill-defined extremists, who it was speculated might be within the group. This can be seen in many of the smaller animal rights groups which were targeted by the SDS. Actions usually involved demonstrations outside premises connected to animal abuse and the homes of those involved in vivisection or the fur trade. And whilst no doubt unwelcome by those who were targeted, it is important to recognize that home visits were a lawful activity at the time, and they were intended to be peaceful. And if there was any public order issue, it would be minor and hardly justified the resources of an undercover policing unit. The lack, we say, of public order threat posed by animal rights groups was recognized by the SDS in this period, and in particular, and ironically, by Bob Lambert, when he recorded in an SDS discussion paper, and I quote, that by late 1984, however, the public order threat posed by various animal rights groups had all but disappeared. Those are the words of the man who at that time was infiltrating these groups. By late 1984, however, the public order threat posed by various animal rights groups had all but disappeared. And he even then went on to criticize undercover officer Mike Chitty for monitoring legitimate animal rights groups in South London and becoming immersed in the cozy world of middle-class animal rights campaigning. There is hence recognition that some SDS undercover officers targeted perfectly legitimate animal rights groups for years without making any significant intelligence contribution. The second point we make is about the taking of positions of responsibility by undercover officers and their influence on groups. In seeking to gain access to personal information on the members of groups targeted, the SDS undercover officers regularly took on positions of responsibility within those groups. This is clearly seen in the deployment of HN2 Andy Coles, a co-founder of LARC, who in his own words took over the running of the ALF-SG when other activists were unable to, and was, in reality, second in charge of the ALF. Undercover officers also influenced the political direction of groups targeted by more informal means. For example, Martin Lowe believes it was Bob Lambert who was instrumental in moving the initial interests of London Green Trees in broad environmental and anti-militaristic matters to become much more focused on animal rights. It would fit with his tasking. As well as being improper interference with political campaigning, these shifts in direction had the potential to cause tension within a group. There is some belated recognition of the deficiencies of the SDS managers in preventing undercover officers from taking on positions of responsibility and influencing groups. As HN 109 states, there was always some concern that personalities would become dominant in an organization. This was true of DS Lambert more than any other officer. He notes, it was assumed that HN10 would stay on the right side of the blurred line that nearly every undercover officer encountered. But notes that, in hindsight, that may not have been a correct view. Finally, in this section, I touch upon lack of supervision. It's at paragraph 127 of our opening. The level of unsupervised freedom given to undercover officers to conduct their deployments was unprecedented. Between requests from the security service to target certain groups and the discretion given to the undercover officers, there was little scope for managers to exercise any proper control over tasking. The lack of supervision and reporting was not confined to SDS managers. Other undercover officers failed to take proper steps to report misconduct by fellow officers. And one example, of course, is HN2 Andy Coles, who turned up late at night and uninvited at the home address of a young female activist. When inside, he made unwanted sexual advances towards her, and the young woman was upset and confided in someone she considered to be a fellow activist and friend. It was none other than Matt Rayner, in fact, another undercover officer. And of course, no action was taken on the concern by Matt Rayner to alert anyone as to this predatory behavior. And of course, there was targeting of vulnerable persons. Concerning the behavior of Andy Coles forms part of a wider pattern exploiting vulnerable persons. It should be recognized that undercover officers were often significantly older than the activists they spied upon. Not only did the Tradecraft Manual recommend that undercover officers knock a few years off when creating their undercover identity, younger and more impressionable activists were often targeted. That happened to men and women. As Paul Gravitt states of HN10 Bob Lambert, it was pleasing being in his company, and he could be charming. I was a young man when I met him, and he was like an elder brother. I looked up to him and respected him, Looking back, I realized there was an element of grooming in our friendship. It's particularly appalling that HN33 Lee Bosner infiltrated Lambeth Women for Peace, used the cover story of a woman escaping an abusive relationship. We say it underlined the sexism and misogyny in the SDS, that somebody would come into a woman's peace group with a made-up story about domestic abuse. The undercover officers were prepared to take advantage of whatever means they could to infiltrate target groups. You, sir, must keep a keen focus on the imbalance of power that often existed between undercover officers and their targets, and the manipulative tactics used, as well as the extent to which such tactics were an inevitable consequence of the decision to deploy officers in long-term undercover roles in an open-ended operation with lack of basic safeguards and with lack of proper supervision. So I turn to our chapter 3 on miscarriages of justice. This obviously is a core area of concern to see and sees the involvement of SDS officers in criminal proceedings increasing in both frequency and seriousness. The problems that arise stem from the policy of total secrecy adopted by the SDS, in which the primary aim of avoiding disclosure of the existence of the SDS operatives was put above concerns over misleading a court or ensuring the integrity of the justice system. And we say this at its heart led to the grave miscarriages of justice. So we summarize in paragraphs 138 to 158 in our opening paragraphs, and we invite you to consider carefully the framework in which effectively they were operating. Essentially, we say, and I hope to summarize these paragraphs in this way, we say the analysis of the various guidance shows that the SDS guidance gave undercover officers in the SDS greater freedoms to participate in crime and to act unaccountably in a way that did not lead up to the standards of the Metropolitan Police Service or even those contained in the Special Branch Code of Conduct. As for the SDS Tradecraft Manual, which Oliver Sanders KC yesterday sought to portray as having a lack of status, effectively, it appeared he was saying it was nothing more than a memoir. That guidance enabled and empowered undercover officers of the SDS to act with impunity, in the belief that they would always be supported by their superiors, free to participate and even incite crime. So I've summarized those paragraphs in that way. So I turn to the paragraph headed the Debenhams improvised incendiary devices. So I don't know whether it's possible to put up the photo of Bob Lambert. We asked for it to happen. If it's not possible, I will move on. But at this stage, it was to be done. And if it can be done at the moment, I would ask for it to be done. But if it's not possible, I move on without it. I move on.
I'm afraid to say that those who didn't comply with the deadline set by the inquiry team have, unfortunately, to bear the consequence that the photographs won't be put up.
But I have no problem with that approach at all. On the night of the 11th and 12th of July of 1987, improvised incendiary devices were planted in Debenham stores in Luton, Romford and Harrow. £340,000 worth of damage was caused to the Harrow branch alone, with £4 million in fire damage and 4.5 million trading losses across all three. Shortly following the incident, Debenham stores stopped selling fur. I simply say that by way of an outcome. SDS intelligence provided by Bob Lambert led to the arrests of Andrew Clark and Jeff Shepherd for these incidents, or may have. Uniformed police officers were able to make these arrests when the two men were in the process of making further devices. The arrest of Clark and Shepherd were clearly celebrated within the SDS and beyond. They are explicitly referenced in the foreword to the 1987 Special Branch Annual Report. The subsequent convictions were similarly lauded. Bob Lambert received a commendation for his alleged role in the investigation. However, his true role was not revealed to those outside the SDS. Certainly, his role was not disclosed to the prosecution at the trial of Clark and Shepherd, as has now been clearly confirmed by Mr. Justice Sweeney, who was then prosecuting trial counsel at the time. As Jeff Shepherd states in his witness statement, Mr. Lambert was initially involved in the planning and execution of the campaign and himself planted or claimed to have planted the devices in the Harrow branch. This is confirmed by Paul Gravett, who was not charged with any offence arising from this campaign. However, an undertaking having been given by the Attorney General not to prosecute non-state court participants on the basis of evidence given to your inquiry, in the light of that undertaking, Paul Gravett was able to provide details not only of his own involvement in the Debenhams IID campaign, but also to confirm the role played by HN10 Bob Lambert. He says that Lambert not only played a part in the Debenhams attack, but that he had also claimed to have perpetrated an incendiary attack on Selfridge's store in the August of 1988. At some time in 1986, Bob Lambert chaired an initial planning meeting for the Debenhams IID campaign. Jeff Shepherd and Paul Lambert were present. This was described by Jeff Shepherd as the genesis of the Debenhams conspiracy, which Bob was integral to. Several meetings followed, at which Lambert was present. Debenhams' store were chosen as targets because they sold fur. Lambert chose to target the Harrow store. Jeff Shepherd had selected the Romford store, and when Jeff Shepherd realised that the Romford store did not have a fur department, he wasn't sure whether to continue with the plan. But Bob argued it remained a legitimate challenge. Jeff Shepherd states, "If it had not been for him persuading me to carry on, I would not have planted the device in the Romford store. He did not simply go along with this plan. He was positively encouraging it and pushing for it." Devices were collected on the 11th of July of 1987 and placed in the department store. The group met afterwards. Paul Gravett informed the others that he was unable to place a device in his store, but by contrast, Bob Lambert stated he had placed one of his devices, as occurred in Harrow. On the 9th of September of 1987, a police search was carried out and found Clark and Shepherd manufacturing devices, incendiary devices. The clear conclusion is that Bob Lambert was central to the planning, preparation, and implementation of the Debenhams campaign in July of 1987. He, we say unsurprisingly, denies this involvement. He maintains that he was merely a trusted confidant of Jeff Shepherd, which allowed him to gain information about the campaign, but that he was not involved in the planning or the execution of the actions. We invite you to examine his evidence carefully upon this matter. So the analysis of contemporaneous reports. We set out in our written opening why the account of Bob Lambert does not stand up to scrutiny when placed amongst the contemporaneous documents. The picture which emerges is of HN10 being privy to information which only those involved in the incendiary device campaign could have known, curating and withholding the extent of his knowledge within STS reports, restricting the flow of information outside the STS, disseminating misleading information outside the STS, and drip feeding the provision of information about who was actually involved in such a manner as to hide his actions. Lambert's only explanation for the discrepancies in the information provided or omitted is the STS's reports, is that it was sanitized by others in the SDS for source protection. However, the evidence discloses that the relevant SDS managers deny sanitizing reports in that way. There also appears to be a scarcity of written records of the intelligence that Bob Lambert was providing. The level of activity which Bob Lambert appears to have engaged in the period around July does not appear to be reflected in the number of intelligence reports that have been obtained by the inquiry. A further telling discrepancy concerns the closed-circuit television footage from the Harrow store, which was seized from the Harrow store at the time the IID was planted. This was recorded as having been obtained by the police. The original exhibits officer has a clear recollection of special branch officers attending and taking custody of the exhibits in the case. After this point, the CCTV appears to have gone missing. Clearly, if Bob Lambert or others connected to him had been involved in planting the incendiary devices, then the CCTV footage might have revealed this. To date, we submit no good explanation has been provided as to why the exhibits were seized by Special Branch and why the CCTV then went missing. So we have concerns about the undercover officers and their managers. At least some managers in the SDS had concerns over Bob Lambert's actions. HM109 says it was difficult to understand how he was obtaining such detailed intelligence on the ALF's incendiary device campaign without being closely involved than he should have been. The value in his intelligence potentially blinded more senior officers to how it was being obtained. Concerns over Lambert's role in the Debenhams campaign were also raised by other undercover officers. Long before any undercover officers or the work of the SDS became more publicly known. In 1994, Mike Chitty met with John Lipscomb, where he is recorded as raising concerns that about SDS officers targeting ALF activity. He's quoted as saying he had no remit for the criminal participation inherent in their work. Regarding Bob Lambert's role in the conviction of Andrew Clark and Jeff Shepherd, he said that undercover involvement in the case far exceeded any provisions under the criminal law or police regulations. So Bob Lambert's actions in securing the arrest and conviction of Jeff Shepherd and Andrew Clark went way beyond the bounds of any conduct which could possibly have been authorized. Lambert played an integral part in the planning and carrying out of the Debenhams IID campaign. Of note, we say, a preoccupation with preventing discovery of his role overrode any concerns over a fair trial for the defendants in the case, if such concerns were ever considered. Subsequent actions in obtaining confidential information about the trial preparation further compounded the injustice. Bob Lambert's later position as a manager in the SDS gave him, and I simply say this, the means to destroy evidence of his true role in the Debenhams campaign when faced with a threat to expose his unacceptable behavior. And it raises concerns over the apparent lack of contemporaneous documentation concerning them. We simply say it raises those concerns. The inquiry, we ask, must expose, or we invite you to expose, the truth of what actually took place. His actions certainly had impacts on others. Bob Lambert's provision of false information in the SDS reports had an impact beyond those who were involved in the Debenhams campaign. I turn to MSW, another of the core participants I represent. Between 1979 and 1984, a person known in this inquiry by the pseudonym MSW was involved in anarchist, workerist, and community circles. They were not involved in any covert illegal activity at any time pointed out during his political activism. MSW was identified in SDS reports as a quartermaster, and we say this is significant, in the Debenhams campaign. Can you stop it? Sorry. This is wholly false and was fabricated. MSW knows nothing about the planning, manufacture, or placing of incendiary devices in Debenhams. He did not and does not know Jeff Shepherd, Andrew Clark, or HN10 Bob Lambert. MSW remains astonished and alarmed to have been identified as a main player in the commission of a serious crime of which he is entirely innocent and about which he had no knowledge. And sir, I simply make this comment upon a statement up on the EPIC system of a witness who's to be called before you. It is interesting to note that fabrication, if you find it to be such a fabrication, in the context of the witness statement of Mr. Green about what was being said about him and his role. And one of the theories that one looks at, and we invite you to consider, is whether there was placing of people into roles that were actually called by undercover officers. So a number of serious allegations of criminality are made in reports by HN10 Bob Lambert, proposed concerning Helen Steele. He was involved in the IID campaign. These allegations are completely denied. We suggest they are likely fabrications made by HN10 for career advancement or to cover his own actions. Some of the accusations made against Helen Steele are alleged by others to be illegal actions carried out by HN10 Bob Lambert himself. The reports are lacking in significant detail and do not provide any contemporaneous provenance for the claims made within them. They are entirely unsupported by any other means. No credible basis for the allegation has been provided. Bob Lambert was able to make such unfounded allegations, demonstrates the complete absence of checks and balances within the SDS reporting system. The lack of detail in reports makes testing the complaints almost impossible, which only serves to compound the injustice caused. HN10's other involvement in criminality other than in Debenhams. Sir Christopher Bailey, who is to be called before you on the 6th of November, was politically active in 1997 to the early 2000s, participating in various anarchist and animal rights organizations. He became involved in London Greenpeace in 1987, and through London Greenpeace, he became involved in the London Boots Action Group. In an SDS report, he was described as one of the most energetic anarchists in London. In 1985, Christopher Bailey was convicted of criminal damage committed with Bob Lambert. He was invited by Bob to Bob Lambert's house, where he was given alcohol and cannabis, and he was then encouraged to travel with Bob Lambert to a butcher's shop where another person broke a window. Bob Lambert and the other individual then drove away from the scene, leaving Chris Bailey to be arrested by a plainclothes police officer. He was later charged and convicted. Christopher Bailey believes he was set up by Bob Lambert. The same applies to the Birex incident. Jeff Shepherd gives a clear account of accompanying Bob Lambert to an incident where he carried out an arson attack on a building. Bob Lambert, that is, carried out an arson attack on a building owned by Birex. He states, it was Bob's idea, and he was the instigator of the action, and he was the person who carried it out, where my role was simply as a lookout. These actions were described in the London ALF News, produced in the spring of 1987 by Bob Lambert himself. In addition to this, he also produced an anonymous leaflet entitled, You Are the ALF, which called on people to carry out direct actions themselves instead of asking others to do it on their behalf. We invite you to fully examine Bob Lambert's involvement. So I turn to Matt Rayner and the later incident. Jeff Shepherd gives evidence of a series of direct actions involving criminal damage, which took place between 1993 and May of 1995, when Jeff Shepherd was arrested and remanded in custody for the firearms matter. He states that the numbers involved on at least some occasions were small, but that HN1, Matt Rayner, was always involved driving activists on actions. Without him transporting us to the location, the attacks never would have taken place, he states. Moreover, in 1995, Matt Rayner took a dummy incendiary device from Jeff Shepherd and placed it in a Boots shop. In his witness statement, Jeff Shepherd states that Matt Rayner persuaded him to get involved in direct action again after his release from prison, and also provided practical assistance transporting him to him and other activists in his van. It was after this series of direct actions that Jeff Shepherd came into possession of a shotgun. This was provided to him by someone he had met whilst in prison, initially for safekeeping. The contact later offered to sell the gun to Jeff Shepherd. The gun was never to be used to cause harm to anyone, and it was to damage cameras or similar as part of direct action. Jeff Shepherd first told HN1 that he'd come into possession of a firearm about 2 months before he was eventually arrested. HN1 Rayner appeared to be quite impressed and happy, and did not voice any concerns or try to persuade Jeff Shepherd to get rid of the gun. The gun was never intended to be used to harm anyone, and Matt Rayner's claim that it would be used to murder a well-known vivisector is false. Apparently, it was on the basis of intelligence provided by Matt Rayner that Jeff Shepherd's home was searched, although we note what was said by counsel to the inquiry in his opening, so far as the lack of documentation, so far as that is concerned, and the approach of the officers who actually attended the scene. Jeff Shepherd was obviously arrested, remanded, and pleaded guilty to the firearms offence and was sentenced to 7 years imprisonment. Of course, no disclosure of an undercover officer appears to be made to any of the prosecution or to the court itself. And it is important to view the manner in which Jeff Shepherd came into possession and kept the firearm in the context of the wider circumstances he was in at the time. He was encouraged to return to direct action by Matt Rayner, who played a vital role in a series of criminal damage actions. It was following this that Jeff Shepherd was approached by someone to look after the firearm. Matt Rayner did not dissuade him from this course in any way. Matt Rayner was again, like Lambert, lauded for his role in securing the conviction of Jeff Shepherd on firearms offences. His deployment as an undercover officer was also extended as a consequence. The case has many parallels with the earlier actions of Bob Lambert, who was a manager in the SDS at the time. Very significantly, there is an absence of contemporaneous reports relating to the action of Matt Rayner over this period. Bob Lambert was a manager in the SDS and was therefore in a position to destroy documents. So I turn to legal privilege, which was another issue. We raised that in our note, in our opening. The SDS reports are replete with examples of reporting on legally privileged material. That happened in connection with Bob Lambert and the Debenhams offences when he visited Jeff Shepherd in prison whilst awaiting trial. Reports produced from these visits contain significant information about the preparation for trial by Andrew Shepherd and Andrew Clark and Jeff Shepherd, including potential pleas, assessment of the prosecution evidence, tactical approaches to the trial, the likelihood of the defendants giving evidence, difficulties in relationships between the defendants and their legal team, and conflicts between the co-defendants, the SDS managers. SDS Manager 109 now accepts that these are deeply concerning in hindsight and does not recall any authorization being sought for the visits. Surprisingly, no consideration appears to have been given as to the propriety of using subterfuge to gain information from a defendant about a forthcoming trial. The officers seek to rely on technical arguments regarding the formal scope of legal privilege to deflect criticism from them. The attitude of SDS managers to legal privilege is particularly concerning. As HM 109 said, I'm not sure I understood at the time what constituted legal privileged information. On that basis, I do not believe I gave any guidance or instructions to undercover officers that there was any policy on the matter. Given this state of knowledge amongst the managers of the SDS, it is unsurprising that legally privileged and other confidential information was routinely recorded and retained. It is symptomatic, we say, of the disdain that the SDS showed towards the legal proceedings in general, and the SDS managers did not properly understand it. So the conclusion is that the participation of undercover officers in criminal activities and the failure to disclose this in subsequent prosecutions and consequential misleading of the court is the most serious of wrongdoings by the SDS. We invite you to fearlessly investigate the circumstances of these cases, however unpalatable the results may be. So I just finally want to use a moment to address the procedural concerns and invite in particular you to turn to our document where we raise concerns raised by Helen Steele. Her case exemplifies the most acute effects of the procedural difficulties outlined by us in our statement. She has set out her concerns in relation to the inquiry's approach to disclosure, deadlines for non-police and non-state court participants, and privacy in detailed and long-standing correspondence to the inquiry. The practical effect of the approach taken is that Miss Steele has been asked to consider many thousands of pages of material under extreme time pressures, which relate to the abuse that she suffered, as well as serious, distressing, and untrue allegations made against her by undercover officers, including John Dines and Bob Lambert. We invite you to give careful and understand the considerable distress and trauma associated with her continual re-engagement with materials relating to these men's abuses. Yet we say, respectfully, instead of taking a trauma-informed approach, the inquiry's imposition of strict and inflexible deadlines in relation to her witness statement and applications for privacy redactions have made Ms. Steele's effective participation really difficult. This is further exacerbated by the inquiry's reluctance to apply privacy redactions to untrue allegations made against Ms. Steele within the disclosed material, despite multiple direct requests to do so, and despite it happening in connection with other witnesses. This risks wrongly shifting the inquiry's focus onto unproven allegations against her, rather than what should be its primary focus and the reasons for which this inquiry was established, namely to establish police conduct in the relevant period. The cumulative impact of this process on Ms. Steele has been significant and is re-traumatizing. Although she commendably regards it as her responsibility to give important evidence to this inquiry, she wishes the inquiry to understand that the consequences, including the extensive invasion of her privacy, have been profound and risk undermining the effectiveness of the inquiry itself, given the unique and crucial evidence that she possesses. The participation of her in the inquiry, we say, is crucial to the inquiry's credibility and its ability to reach fair and just findings. So, in our conclusions, we simply drew your attention to two authorities which give useful passages, and ironically, to the European Court's judgment in the case of Steele and Morris against the United Kingdom. In that, the European Court stated, and I'm now at the very end of our opening statement, the government had pointed out that the applicants were not journalists and should not therefore attract the high level of protection afforded to the press under Article 10. The court considers, however, that in a democratic society, even small and informal campaign groups, such as London Greenpeace, must be able to carry on their activities effectively, and that there exists a strong public interest in enabling such groups and individuals outside the mainstream to contribute to the public debate by disseminating information and ideas on matters of general public interest, such as health and environment. Sir, I pause. Had the European Court been aware at the time that they said those words of the gross intrusion that was ongoing by state operatives in these organizations, I'm sure the words that would have been uttered would have been more forceful. These passages cited contain important principles concerning the state's conduct in relation to protest. Free speech encompasses campaigning, letter writing, demonstrations, marches, pickets, and even direct action. Freedom of expression in all its forms is an essential requirement for democracy, and the actions of the SDS, as disclosed in this phase, fail to recognize the inherent value of protest movements of all types. Worse still, the SDS represented the worst in our society, a cynical attempt by the state to use its policing powers in order to secure political advantage. So the SDS was a unit within a state establishment that we say was incapable of properly balancing the civil and democratic rights of individuals against a desire for unlimited intelligence capture. It should not have existed. And more importantly, those in power should never have enabled it. So I thank you for your understanding. I will ensure that the electronic copy is with you, as it will undoubtedly assist you. I don't want to go into why there was such a difference between the two, but there was. And I finish my remarks.
Thank you. May I say two things to you? First is in relation to the procedural difficulties that have been encountered. There are numerous views about that, and now is not the time to go into it. If ever there is an appropriate time, it will be at leisure and later. Secondly, may I ask you, because one of your clients is Helen Steele, to communicate to her, if she's not listening to what I am saying now personally in any event, that I acknowledge that she has produced a detailed and informative witness statement, in part without the assistance of her lawyers. It is of the greatest assistance to me in attempting to get at the truth of what occurred all those years ago. And I am encouraged to hear that she wishes to support it with her oral evidence. May I ask, through you, that she produces to the inquiry in the very near future, rather than at the time she gives evidence, the documents to which she's referred, in particular the photographs.
I will certainly convey, and my solicitor who will be listening on will no doubt ensure that takes place. Thank you, sir, and I apologise that I grossly overshot my time allowance, but we have struggled to reduce the submissions we had to make, and I apologise for that.
Not at all. You have stuck well within the time that you have been allowed when you rightly drew to the attention of the inquiry staff that you were unlikely to be able to complete within the allotted time. You have not,
Thank you very much.
You have not exceeded your the reasonable bounds of what should be available to advocates in the least. Thank you.